Hey everybody, how's it going? Welcome back to Copper Jacket TV. So there's really nothing quite like ending the year on a high note, especially with a major Second Amendment victory, which is what we're going to be talking about today. A victory that was so big that even the Biden appointed judges voted for the 2A. So let's talk about what happened. Now, real quick, if you're somebody who carries to defend yourself or your loved ones and you're doing so without an attorney in your back pocket, you are doing it the wrong way, because heaven forbid you're out there and one day you actually find the need to defend yourself and the details get a little bit fuzzy. You could be the one that ends up in handcuffs, in which case you will need somebody on your side, and that's where Attorneys on Retainer comes in. Now, with that Attorneys on Retainer membership, you do have an attorney in your back pocket, because if something, God forbid, happens, all you have to do is simply call the number on the back of that card, and you will speak to an actual attorney who can guide you through the next steps. They will also get an attorney out there to defend you. You can choose one from their network, or you can choose your own attorney. They are not an insurance company. These are attorneys that are working directly for you. So it is the same as having an attorney ready to go in your back pocket at all times. Okay, so let's go and talk about what's going on here. So we're talking about a major victory, an en banc victory out of the Third Circuit Court of Appeals in the case of Brian Range. Now, Brian Range was convicted of a non-violent felony. If you ask me, it was something that was completely trivial, and it wasn't until I started this channel that I learned how many small trivial things can turn into felonies, in which case you would lose your Second Amendment rights just like he did. Now, to illustrate my point of how absolutely absurd some of these non-violent felonies are that could cause you to lose your constitutional rights for the rest of your life, we can just take a look at the court documents here that summarize what happened to Mr. Range in one paragraph, where it says, "The material facts are undisputed. In 1995, Range pled guilty in the Court of Common Pleas of Lancaster County to one count of making a false statement to obtain food stamps in violation of Pennsylvania law. In those days, Range was earning between $9 and $9.50 an hour as he and his wife struggled to raise 3 young children on $300 per week. Range's wife prepared an application for food stamps that understated Range's income, which she had Range sign. Though he did not recall reviewing the application, Range accepted full responsibility for the misrepresentation." So that's it. Because of that, because on the application it was slightly understated how much he actually earned, he lost his Second Amendment rights for the rest of his life. And thankfully, he decided to fight back. Now we end up at the Third Circuit Court of Appeals, an en banc panel, 15 different judges, Biden appointees, Obama appointees, and this is the outcome that we got, and this is the major victory. So here it says, in the opinion, Brian Range appeals the district court's summary judgment rejecting his claim that the federal felon in possession law, 18 U.S.C. 922 G1, violates his Second Amendment right to keep and bear arms. We agree with Range that despite his false statement conviction, he remains among the people, quote unquote, protected by the Second Amendment. And because the government did not carry its burden of showing that the principles underlying our nation's history and tradition of firearms regulation supports disarming Range, we will reverse and remand. Now, what's really interesting here is just how big the margin of victory actually was. Out of the entire en banc panel for the Third Circuit Court of Appeals, only 2 judges dissented, and those 2 judges were Obama appointees. So that means a vast majority of the Third Circuit actually voted to restore Mr. Range's rights as a non-violent felon. Again, that's absolutely massive. Now, they did so because obviously the text of the Second Amendment is implicated. Mr. Range is still part of what we quoted earlier, the people, and the government failed to show any historical analogs or any relevant historical analogs that could uphold the government's law as it is applied today. So again, the government failed its burden, and so a majority of the Third Circuit voted to restore his rights. Now, while this case applies to Mr. Range and the restoration of his rights, you can see the implications here. Again, that the Third Circuit, a vast majority of the Third Circuit en banc panel would vote to restore his rights is a good sign for other people in similar situations. And with an incoming administration that is supposed to be friendly to the Second Amendment, if this case gets brought before the Supreme Court, we could see people in similar situations to Mr. Range have their rights restored across the country. So again, this could be a huge thing and one of the biggest things that happens for the Second Amendment in a long time. So again, I would love to see this go up to the Supreme Court. We'll see what happens with that. But again, a major victory at the Third Circuit here that I wanted to share with you. And again, just seeing how many judges actually voted to restore his rights gives me a little bit of hope for that appellate court. So I want to share that with you. I want to thank you all very much for watching. Merry Christmas to everybody out there and a Happy New Year. You guys take care.